Good afternoon. I'm Joey Wender, Executive Director of the Shelby Coalition. It's my pleasure to welcome everyone to today's webinar entitled Debriefing the SCOTUS USF Oral Decision. I'm joined on this webinar by Kristen Cora, Shelby's outstanding policy counsel, who will co-moderate this webinar with me. As you probably know already, the Shelby Coalition and many others scored a huge victory a couple weeks ago when the Supreme Court, in a 6-3 decision, upheld the constitutionality of the Universal Service Fund, which includes both E-rate and the Rural Health Care Program. Shelby was a named party in the case, which makes this win that much more special. As background, with the support of the HWG law firm, Shelby had filed an opening brief and a reply brief with the Supreme Court earlier this year, along with our friends Benton, NDIA, and Media Justice. The webinar will help our audience understand the court decision and discuss what comes next. That's why, as we did with our first two in this series, before and after the oral arguments, we have two absolutely outstanding legal experts to help us understand what happened in the final decision. Jason Neal is with the HWG law firm and has been Shelby's lead attorney, drafting our briefs and providing outstanding legal advice. In addition, we have the renowned public interest advocate, Andy Schwartzman, joining us as well. We look forward to their takes in just a few moments. But before we get started, just a couple reminders about logistics. The webinar is being recorded and will be available on our website afterwards for all to watch. Audience members are muted, but we encourage you to use the Q&A box, not the chat box, to send us your questions. And as always, you could follow us on social media at Shelby Coalition or hashtag Shelby Webinars. I also want to thank our corporate sponsors, Ready, Zayo, T-Mobile, Cisco, and Tirana. We would not be able to bring you this excellent content in these webinars without their financial support. I also want to have a special thanks to the American Library Association, ALA, for helping co-hosting this webinar and for their constant partnership on these issues. Finally, I want to encourage everyone on this webinar to attend AnchorNets. It's the nation's leading broadband conference for anchors. This year's conference will be held October 29th through 31st here in DC, so you should register today. And if you enjoy and value these webinars, please do consider becoming a Shelby member if you're not one already. Okay, it's time to turn to the issue and the court decision. We're going to start with Jason. Jason, on the last day of the term, the Supreme Court handed down a decision in Consumers Research versus the Federal Communications Commission. What did the court say?
Thanks, Joey. I could go on for 30 minutes on this, but I will try to keep it to just a few minutes. I will start by reading from the first page of the court's decision itself, just to give everybody a flavor of how the court addressed this. They said, quote, "We hold that no impermissible transfer of authority has occurred. Under our non-delegation precedents, Congress sufficiently guided and constrained the discretion that it lodged with the FCC to implement the Universal Service Contribution Scheme. And the FCC, in its turn, has retained all decision-making authority within that sphere, relying on USAC only for non-binding advice. Nothing in those arrangements, either separately or together, violates the Constitution." So that is the core of the court's decision here. And I mean, we can break it up into the three big issues in the case and the conclusions that the court reached on each. First, Congress permissibly authorized the FCC to implement its directions on universal service in Section 254 of the Communications Act. Second, the FCC, in its regulations regarding its relationship with USAC, permissibly works with USAC in determining the contribution factor. And third, the combination of those two things does not create some separate problem, as the Fifth Circuit had concluded in its decision below. So the key of what the court decided here is that the constitutional challenge to the universal service system is rejected, and the Universal Service Fund can continue in its current form. I can walk through, Joey and Kristen, now, if it is helpful, kind of the arguments that were key to the court's opinion. I will do that unless you tell me to stop. Um, on the non-delegation doctrine issue from Congress and its authorization to the FCC, the big argument that the other side had raised here was that there should be some special rule for what it called revenue raising statutes. They said that universal service contributions were a tax and that there's a different rule for taxes. Um, the court's decision, with no reservation here, said it does not matter whether this is a tax or a fee, and there is no special rule for taxes or fees. The test for the non-delegation doctrine, as it has been for decades and decades and decades, is the intelligible principle test, where Congress has to give guidance and guideposts to federal agencies in implementing its directions. Here, the other side's position, as we talked about on the webinar just after the oral argument, essentially they were taking the position that an effectively infinite cap, $5 trillion, pick the biggest number you can think of, that would satisfy their constitutional concerns, but that it was not okay that Congress had given the FCC all the direction here without some sort of a cap. And the court rejected that out of hand, saying it would do nothing to vindicate the non-delegation doctrine, or more broadly, the separation of powers. Again, that echoes what we saw in the oral argument from some of the key justices that we were paying attention to, Justice Barrett and Justice Kavanaugh, both of whom joined the majority here, where they, essentially were kind of left scratching their heads like, what are we doing here if all of these words in the statute are not good enough, but if you add, $1 trillion or $5 trillion into the statute, all of a sudden all of these concerns disappear. So the way that the court addressed this, because there is no special rule, was to ask itself, under the intelligible principle test, has Congress provided ascertainable and meaningful guideposts for the FCC on how much to raise and what to spend it on? And the court concluded, yes, it had. With respect to how much to raise, the court focused on the word sufficient in the statute, where Congress had said you need to raise sufficient funds for the Universal Service Fund programs. And sufficient does not just mean enough to do that and more. It is what the court said, a floor and a ceiling. You raise enough to do the job, you don't raise more than that. Is it a black line where $1 separates constitutional from unconstitutional? Of course not. But the court was satisfied that sufficient told the FCC, you can raise the money that you need for these programs, as we have told you to do, and only that. Then the second question was, okay, well, what can you spend it on? And again, we've talked on webinars before. Section 254B provides a long list of principles that the commission has to follow in designing the programs. Section 254C provides the FCC factors and considerations it has to look at in deciding what meets the definition of universal service under the statute. There's a ton in the statute guiding the FCC, and the court, walked through it, and much like we in the government did in our brief, concluded that this statute tells you, who needs the support, what kind of support can they get, who needs to pay it. All the key questions were answered, the court concluded here. And then just very briefly on the second and third issues presented here, the court was, I don't even want to say less troubled, because it wasn't troubled on the non-delegation doctrine issue, but it had easier work, I think, in deciding the private non-delegation doctrine question regarding the FCC and USAC. I think the court looked at the FCC's regulations on how it decides the contribution factor. There are several places that make clear that while USAC does these projections and calculations, ultimately it is the FCC that reviews that work. It is the FCC that decides the contribution factor itself. Nothing here hands off that authority to USAC. It is the FCC that decides the contribution factor, and that is that. The other side had raised some arguments about, well, effectively it's a rubber stamp because they never tell the USAC that they got the answer wrong, and the court said, number one, that doesn't matter. What matters is that they actually have to review it, and they do. And number two, the fact that they don't tell USAC it got everything wrong here is actually a reflection of the minimal task that USAC has here and how much it's already constrained by what the FCC has told it to do. So we were really pleased to see that because in our briefs, we just thought this was something where if you understand how the regulation works, we thought that was clearly the right answer. So it was really good to see that from the court. Finally, on this contribution theory from the Fifth Circuit, again, previous webinar recipients or attendees will remember the Fifth Circuit did not actually conclude that Congress violated the non-delegation doctrine. It didn't quite conclude that the FCC violated the private non-delegation doctrine. It thought that its concerns about both of those could come together to create a new constitutional violation, and that is actually what it ruled on. And the Supreme Court said that is not how the law works here. We have cases where you've had similar fact pattern, and we did not look at how two non-violations might somehow combine into a violation. That's just not the way to do it here. So the court, I think with no dissent on that, or the private non-delegation doctrine, if memory serves, decided those issues in our favor. So we are left with 6 justices, all joining the majority opinion, concluding that USF is constitutional. The Fifth Circuit is reversed, and it's a big win for USF. USF continues, and that's the majority opinion.
Well, thank you so much, Jason. Appreciate that rundown. Definitely, I know it was definitely a very good day for a lot of folks out there who are waiting for this decision. Appreciate that. And I know I've seen some questions and some comments already coming in. So just reminding folks, if you do have specific questions for Jason or Andy, please put them in the Q&A box and we'll try to get to them. So Andy, let me turn to you. So do you want to summarize, Andy, some of the key takeaways from the decision?
Yeah, well, the most practical thing to know, the real impact of this decision is, first of all, I'm sorry, when I had my background and my right shoulder kept disappearing. So I apologize for the first couple minutes there where my right shoulder was going away. So I gave up on the background. So as I said, the real impact is no impact. We are exactly in the same place we were the day this litigation started. USF is there, USF functions, USF is okay. So the biggest change is no change. And that's a very important thing. It's a big win. But that highlights that this has been a huge annoyance, diversion of resources, and created a lot of uncertainty. And it's kind of held the calls for some legislative reforms and fixing up some of the issues that USF have. Put all that on ice. Now we can start moving forward with that. So that's a positive view of the no impact. I'd stress a couple other things. First of all, this was the 6 majority was a unanimous decision, joined in full. No quarrels or quibbles about any part of it on any part of the 6 justices. And it pretty much puts to bed conservative scholars' calls to revisit the New Deal era precedents about non-delegation and the so-called intelligible principle. It's firmly rejected. And that's good for USF and it's good for the government delegation powers in general, and that's a very positive thing. I would note that Justice Kavanaugh wrote a concurrence. He joined the majority in full, but he kind of showed what I think, part of what was going on here. He pointed to the fact that in the last couple of years, they've overruled the Chevron doctrine in a case called Loper Bright, and they've adopted something called the Major Questions Doctrine in a case called West Virginia v. EPA, each of which significantly constrain the implementation of congressional legislation by independent agencies and an executive branch. And he said, in effect, we don't really need to fiddle with the non-delegation doctrine because our work is done here. The other notable thing, two other notable things about Justice Kavanaugh's concurrence. Number one, he said, of course, I don't believe that there's such a thing as an independent agency like the FCC anyway. They're all part of these bicameral multi-member agencies like the FCC are really part of the executive branch, notwithstanding what a lot of other people think. And I might have to rethink my thoughts about this case if that were otherwise. Now, that really may not matter a whole lot because, unfortunately, from my perspective, I think the Supreme Court is soon going to issue decisions that will agree with Justice Kavanaugh about whether the FCC is truly independent, whether the president can remove members at will, and so forth. So, that's one thing. The other thing, which has no bearing at all on this case in USF, is that Justice Kavanaugh put in a little proviso that he was referring to domestic matters. And the reason that's significant, not here, but significant in the long term, is that one of the lower court cases involving the challenge to President Trump's new tariffs ruled on the major questions doctrine, saying that major questions doctrine preclude the tariffs, and Justice Kavanaugh saying, well, major questions doctrine only applies to domestic cases, kind of signals where he's going on the tariffs. And that's kind of interesting, although not immediately relevant to us. I also should speak briefly to Justice Gorsuch's dissent, which, as is often the case with him, are very interesting. He has led the charge on the administrative state, so-called, long before he joined the Supreme Court. He was attacking Chevron as an appeals court justice and was very much leader of the charge. So he is disappointed not to have this extra weapon, and that kind of underlies some of his dissent. The first couple pages of his dissent are worth reading for a good, reasonably objective history of universal service. There's some very good longer histories in the amicus briefs that people can download to look at it. But because it's easily accessible, Justice Gorsuch really does a nice little tutorial on the history of universal service in a page or two. That's kind of interesting. In terms of what he said, he thinks this was an unconstitutional delegation of authority, while the majority said it doesn't really matter whether it's a tax or a fee or whatever, because it's all the same. It's either permissible or it's not permissible. He thinks that it does matter that the Universal Service Fund collections are taxes, and that this was an unconstitutional delegation of congressional taxing authority, which he thinks there's a higher standard. He thinks that Congress gave insufficient guidance, and notably the sufficiency issue that Jason mentioned. That was really one of the highlights of the oral argument, was Justice Kagan trying to suss out what sufficient meant. Was she said, if I ordered pizza sufficient for 10 people and a 10-wheeler showed up full of pizza, was that sufficient? Sufficient is then a floor and a ceiling, and I think she got very much the best of it, and he's still quibbling about it. He also, and this also came up in our argument, thinks that you need a quantitative limit, that it's not enough to have the qualitative limit of sufficient. And that's a key part of his objection. I guess finally, Justice Gorsuch does point to some statutory challenges that were not made because this was a constitutional case, and he thinks that maybe there's some provisions of the statute that the FCC in implementing it hasn't fully done, and kind of try to write a roadmap to some future challenges. This, if these were brought, they might nip at the edge of the Universal Service Fund programs, but not really hit it too hard, even if those challenges were successful. There's obviously a lot more in these opinions, but I think those are the most important takeaways.
Wonderful. Thank you, Andy. Jason, so I want to go back to you, and Andy, feel free to chime in if you'd like as well. So we saw in this opinion that the court reinforced, they did not abandon the longstanding intelligible principle test for the non-delegation doctrine. So what does this mean? What's your takeaway from that? Is the intelligible principle test safe given this decision? Will the justices want to revisit this in the future?
I would be maybe a little bit, I'd phrase it a little bit differently than what I heard from Andy, which is, the the challengers in this case ultimately did not quite ask the Supreme Court to overrule the intelligible principle test. They had litigated the case in the lower courts very much in a way that would lead you to think that they were going to do that. And I think at the oral argument, some of the justices were a little bit confused that they had litigated it that way and then now had this, there's just a special rule for this one kind of statute that would just be subject to a different rule. Um, so because they didn't ask and the court didn't officially say no, this is not a decision where the Supreme Court said, we absolutely now and forever are going to use the intelligible principle test. With that said, I do think that both the majority and Justice Kavanaugh, as Andy said, kind of hinted that a lot of the recent work the Supreme Court has done to limit Congress's ability to delegate important issues to federal agencies and to limit the authority of agencies under broad language and statutes. I think it kind of takes the wind out of the sails to some extent, at least among the members of the court, of the immediacy of their desire to revisit this doctrine. That is an argument that we had raised in our briefs, to say, number one, this is a constitutional statute, full stop. But also that you've done a lot in this area that already provides lots of constraints. And so if you have a policy concern that is underlying all of this, it's just different now than it was before. And I think that has really landed with the court. These other attorneys may still have a desire to challenge the intelligible principle test. It's possible that it could make its way to the Supreme Court again. I wouldn't expect it to do so in the immediate future. And what we have here, as relevant to us with the Universal Service Fund is, we have a clean decision from the Supreme Court applying the test and saying this passes. That is the most important thing for the non-delegation doctrine as far as USF is concerned.
I've just realized that in our discussion, I don't think we've really addressed what was a centerpiece of the Fifth Circuit decision that the Supreme Court reversed, which is that they took this kind of wacky view in which they said, well, we don't need to really decide if Section 254 is unconstitutional under the non-delegation doctrine, or whether the creation of a delegation to USAC is unconstitutional, a violation of the so-called private non-delegation doctrine, which Justice Jackson took a little time to criticize even the theory. But the Fifth Circuit said, it doesn't matter because taken together, they're definitely unconstitutional. And nobody embraced that. Nobody, I mean, I think the Supreme Court majority had trouble taking it seriously to begin with. And Justice Gorsuch didn't try to revive it. He went straight at Section 254, it violates the Intelligible Principle Act, and that's all you need to know. So that was an interesting component of that of the Fifth Circuit decision we haven't mentioned.
And Andy, I have a follow-up question there, because as someone who was obsessively checking for weeks, right, on all the court decision dates, waiting for this decision to come, there seemed to be a theme here. And the theme that I noticed, and this is from a recovering lawyer myself, was the Fifth Circuit got struck down a lot this term, right? I'm just curious, Andy or Jason, if you want to comment a little bit more, because you use the term a wacky theory, but you want to go in a little bit more about what the fact that this was a Fifth Circuit decision that was we lost on remand 9-7. What does that mean generally where we are now?
Well, it is the case that in this term and last couple terms, the Fifth Circuit has gotten reined in a good bit. It hasn't seemed to stop them a whole lot yet, but the Supreme Court is really kind of wagging its finger at them, saying, "Come on, just we're giving you plenty of latitude, but don't reach for the moon here." And of some relevance to us was a decision a week or two before the Universal Service Fund case involving the Nuclear Regulatory Commission in the state of Texas, which had to do with whether you need to go to the agency, in our case, the FCC, and file something before you can run to court to appeal it, this so-called exhaustion of administrative remedies. And the Fifth Circuit had a unique circuit precedent, not shared by any other circuit, that said that in many cases you can go straight to court. You don't even need to raise your problem with the agency below. And it knocked that down, and that is helpful to us in some respects, and is worth mentioning. But yeah, the Fifth Circuit has replaced the old liberal Ninth Circuit as the bane of the Supreme Court's existence. They certainly agree as a policy matter, and in many cases agree with what the Fifth Circuit is doing, against some things like standing, but they're trying to rein them in for that purpose. I would note that we may well get a couple retirements before the end of the Trump term, and Trump appointees to replace them, and Andrew Oldham, who's I think chief judge of the Fifth Circuit, who wrote the opinion below, is a leading contender for a Trump appointment to the Supreme Court. So he would earn the right to do wacky stuff on the Supreme Court if that happened.
And I would add another way to view this, that the Supreme Court is reversing the Fifth Circuit a lot, not all the time, is that cases get to the Supreme Court, typically one of two ways. An important federal statute or program is declared unconstitutional, or you have a circuit split. In cases involving the government, you often need one of those two things to happen for the case to get to the Supreme Court in the first place. And so, one way to look at what's been happening in the Fifth Circuit to some extent is that they have a perspective on the law. They want to move the law in a certain direction, or, judges that get certain cases do. And, whether it's them or the Supreme Court, they kind of have to act aggressively in order to move the law in that direction. Either their decision stands, or the Supreme Court at least has to consider the issue. And some people have theorized about, kind of how we got to the 9-7 decision in the en banc Fifth Circuit here, and, what did it take to get 9 people to vote together? I don't know the answers to any of those questions, not having been inside their chambers. But, if their goal was to get this issue teed up for the Supreme Court, then they got it done.
Jason, we actually had a question come in through the Q&A that we thought might be good to elaborate on here quickly. So somebody asked about the current litigation that is going on right now in the Fifth Circuit regarding the FCC's school bus Wi-Fi program. So can you talk just a little bit about why that's relevant here?
Sure, happy to talk about it. That case is pending, so I will try to make sure that I describe it carefully and also accurately. So this is a case where 2 people who, as Andy mentioned, did not participate in the FCC's proceeding before the FCC issued the declaratory ruling stating that Wi-Fi on school buses could be a supported service under the E-rate program. They didn't participate in the proceeding up to that declaratory ruling. They went to court and they challenged this in the Fifth Circuit. Their argument is not a constitutional one. It is that the FCC went beyond what Section 254 allows it to do. And the FCC, at least under Chairwoman Rosenworcel, and Shelby has been involved in the case, we have disagreed with their interpretation of the statute. we think that the E-rate program under Section 254, just not to get too far in the weeds without it in front of me, is wide enough to accommodate this program. But the government had moved to dismiss the case on the theory that either under the Hobbs Act or under the Section 405 of the Communications Act, you have to participate in a proceeding to bring a challenge. Otherwise, you have to file a petition for reconsideration first. All of this is, kind of procedural wrangling. But the underlying principle being, if you want to go to court to complain about something that the FCC has done, you ought to participate in the proceeding and make your arguments there first. That is this idea of administrative exhaustion that Andy referred to. And this NRC versus Texas case that the Supreme Court decided recently, I think really reinforces the arguments that we in the government had made, that there is not some broad-ranging exception under this ultra vires theory that just because you think the FCC exceeded its authority under the statute, you get a free pass to do what others don't get to do. We filed a brief on this very recently, as did the FCC, and we will see what happens in the Fifth Circuit. But that's what's been going on in the school bus Wi-Fi case.
I think maybe I missed it, but Jason, you referred to the Hobbs Act without explaining, and let me just say, the Hobbs Act is the provision that provides how one files appeals, technically called petitions for review of FCC decisions. It's a statute that applies to a number of agencies. So that's the way you file a case. And the argument that the issue that the Supreme Court resolved was whether under the Hobbs Act, you need to go to the agency first.
Thank you for explaining that to our listeners, Andy. Andy, can you go into a little bit more detail? We're having some questions come in about potential future litigation. I think you touched on it in your opening. If you want to just elaborate for another moment about what happens from here.
Well, as I said, Justice Gorsuch pointed to a couple statutory issues involving construction of Section 254 and whether the FCC went beyond the scope of what Congress defined there. And we are operating, as we've already discussed at some length, in the context of the Chevron having been overruled. So agencies are confined much more to the plain language of the congressional text of the statute than previously, where expansive agency interpretations got deference from the Supreme Court. So those are potential avenues. I'm not overly worried about it, even in the Fifth Circuit, but we may well see some challenges in that regard going forward. There is also an issue that, again, I'm not overly worried about, that's flagged in footnote 9 of Justice Kagan's decision, which points out that there was not direct challenge to the constitutionality of two provisions of Section 254 that are the most expansive portions of the statute. And it kind of left the door ajar a bit. That's the kind of footnote that sometimes shows up in order to keep the majority together and avoid getting a concurring statement or partial dissent or something. And so that footnote probably appeared to mollify one or another justices rather than necessarily reflecting a significant problem that the majority of the court had with it. In any event, we are likely to see some additional action on that, but I'm not overly worried about it.
Great.
Yeah. And I'll just say, if you go look at the decision and read the footnote, to me, the key is these arguments were not raised in the briefing before the Supreme Court. The Fifth Circuit did not focus on those provisions because nobody had put them at issue in the case. So, the court, I don't think was hinting that there's an issue there. It's just saying those are not raised here. We don't need to address them. Kind of that's that for this case.
Great. Kristen, do you want to ask one more question before we wrap up? Mute.
Oh, sorry about that. Sure. So one final question I just had for everybody. Was there anything in the decision or concurrences that really surprised you? I know Andy brought up the example that Kagan gave about delivering the pizzas, and we heard that during oral argument. Was there anything in the decision really that took you by surprise, either positively or negatively? Andy, do you want to start?
Um, I, not really, I guess. It was all pretty much flagged. I alluded ever so briefly to Justice Jackson's concurring statement. This private non-delegation doctrine, which was the argument that even if Section 254 is constitutional, creating USAC and delegating FCC authority to USAC was unconstitutional. Uh, I thought that was a pretty lame argument to begin with, and as Jason was describing, the court put it to bed quite quickly because the FCC rides very close herd over USAC. And if you don't believe me, talk to some of the USAC people. Uh, uh, but she said, "Well, the whole thing is ridiculous. Let's just get rid of it." And I didn't sort of expect anybody to sort of just say, "Forget about it." So that was kind of surprised me a little bit.
I will say the biggest surprise to me, and it was definitely a positive one, was that Justice Kagan had the opinion. Given the votes that we needed to make sure that we could count to 5 or 6 justices, often if you have the coalition building that needs to be done, the votes that are hardest to get sometimes get those decisions so that they can write very carefully and say, within these lines, I'm okay. To see that Justice Kagan, who from the oral argument we could see really understood this statute, really understood these issues, that she was the one assigned the opinion and was able to write so clearly and forcefully about the importance of universal service, the importance of the historical context here and how we got to where we are, together with, she's a great and witty writer. To me, just amounted to a really fun read the morning that it came out. And
Well,
I will
I
also
agree with
say,
that, Jason, and I think it's a good reminder. You're supposed to celebrate the good days, right? Because there's not every day is a good day. And I think Jason is making an excellent point. Like, first of all, we could have lost, right? Or we could have had a much more limited or split decision that was written by a justice that would not have written such a strong, forceful defense of the Universal Service Fund. I mean, I got to sit in an oral arguments as well. And I remember walking out thinking, God, I wish Elena Kagan wrote the decision. Like, that's the person you want writing the decision. And she wrote the decision, right? And Roberts and Kavanaugh and Coney Barrett all signed on. And in fact, Coney Barrett and Chief Justice Roberts signed on with no concur, nothing else. They just put their name on it. And I guess we could end there. I don't, Andy wants to say one more thing. Like,
Well, yeah,
really significance.
I've alluded to that already, but it's worth underscoring. There is a big difference between a case where you have 2 or 3 different opinions where there's a little bit of difference among them, and sometimes they join in part 1 and part 3, and in the judgment of the court, but not in part 2. Those kinds of things. That detracts from the force and applicability of a decision. The fact that you had a firm 6-judge justice majority all agreeing on every part of Justice Kagan's decision is very significant, makes the decision much more powerful. And again, that's the kind of thing that Justice Kagan is really good at. She is really, really good at finding consensus, drawing the justices together. And I think that's an important takeaway from this thing.
Thank you, Andy. Well, we are going to close our webinar here. First, huge thanks to Jason and Andy for not just this webinar, but for our 3rd in this series. And as I joked, hopefully there's not a 4th. We have now won the case and really appreciate their insights. Also want to thank our sponsors, Ready, Zayo, T-Mobile, Tirana, and Cisco. And again, special thanks to the American Library Association, ALA, for co-hosting this webinar and for all of the work we do together. I should note that there will be more webinars coming. The work is not done. If you saw our statement after the decision was released, the action is now turning to the Congressional Working Group, right?
Joey, can I put a coda on before you hit the button?
Sure.
I think we forgot to plug the explainer that I wrote. It's in the chat, and the first item on the chat, I believe. There's a link, and it's on the. If nothing else, go to benton.org, and I wrote what I hoped was a plain language explanation of some of the things we've been talking about.
Yeah, it's there. There it is again in the chat, and and it ends with we're back. Andy was a great piece, and we always appreciate your insights. And Andy is right. We're back where we were a few years ago. All right. And now the conversation is going to return to the conversation I think we should be having, right? And it's how to strengthen the Universal Service Fund, not how to kill it, but how to strengthen and modernize it and ensure that the fund is predictable and sustainable in the long run. And so there'll be much more coming from us, from Benton, and from others on that front. So please stay tuned. A couple more items to cover. If you've enjoyed these webinars, please do become a Shelby member today. It's easy to sign up, and we really need your support. Finally, I'll end with this. We're going to encourage everyone to attend AnchorNets. It's the nation's leading broadband conference for anchors. I think there was a question in the chat about when the agenda will be posted. The answer is very soon. We have many, many, many panels that have already been confirmed, as well as plenaries that we've announced and will soon be announced. So please stay tuned. The conference will be held October 29 through 31st here in DC. So please register today. With that, again, I want to thank Andy and Jason. This has been a years-long journey here through this case, and it is really an incredible thing when you win a case 6-3 before the Supreme Court that upholds the thing that we care so much about, which is the Universal Service Fund. So huge thanks to the Shelby team and to Andy and Jason for being on. And see you again next time. Thanks so much.
Thanks, Joey. Thanks, everyone.